A very good morning to our respected resource person, Professor Dr. Nishtha Jaswal, Vice-Chancellor, Himachal Pradesh, National University, Shimla. Professor Dr. Komalodich, Head Department of Law, SRM University, and all the participants. I, Shraddha Oberoi, welcome you all to the first session of fifth day of the Faculty Development Program on Contemporary Issues and Changing Facets of Law. It is my pleasure to introduce our honorable guest, Professor Dr. Nishtha Jaswal, who has been a mentor for so many students, including me, and has always encouraged us to do hard work in life. Ma'am, I want to convey my heartfelt gratitude for accepting the invitation. Dr. Nishtha Jaswal has published various papers, presented in various conferences and seminars, and also published various books such as on environmental law, human rights, socio-economic reforms, and others. She has been awarded the British Academy Visiting Professorship in 1992. She has received the university, state government, and national merit scholarships and was designated as Meher Chand Mahajan Professor of Law by Punjab University, Chandigarh. She was conferred the Vishisht Saman, the highest award of DAV, in April 2019 by DAV Educational Managing Committee. Ma'am has held multiple positions in administrative and academic capacities, such as Chairperson, Department of Laws, Punjab University, Chandigarh. She has also served as Dean Student Welfare, Women, Punjab University, and was a former Chairperson, Punjab University Committee Against Sexual Harassment. Apart from that, she has also been a member of various bodies, including Chandigarh Commission for Protection of Child Rights, Advisory Committee Nari Niketan Chandigarh, Punjab Legal Services Authority, Anti-Sexual Harassment Committee of Chandigarh, Judicial Academy. Today, Professor Nishtha Jaswal would be speaking on transformative constitutionalism. The role of the court is to understand the central purpose and theme of the Constitution for the welfare of the society. Our Constitution, like the law of the society, is a living organism. It is based on a factual and social reality that is constantly changing. Sometimes a change in the law precedes societal change and is even intended to stimulate it. Sometimes a change in the law is the result in the social reality. Indian courts have viewed the Constitution as not merely an amalgam of parchment, guarantees against the state excesses, but as a document embodying a vision of fairer, more inclusive, and more progressive society. In this context, I would now request Ma'am to kindly address the participants.
Thank you, Shraddha. Dear participants, good morning. And the topic, I think, which is made part of the sub-themes by Dr. Komal is a wonderful topic, transformative constitutionalism. For understanding it, first of all, you must understand what is constitution, what is constitutional law, and what is constitutionalism. Constitution is not merely a book which we go to the market and purchase because we have to study it, we have to teach it. It's a legal document which has legal sanctity. And this document sets out the framework for the principal organs of the state. Not only their functions, their limitations, their operations, and in fact, we can say we talk about almost everything when we refer to the Constitution. We refer to the three organs of the state, whether it's lawmaking, whether it's law enforcement, whether it's judicial review. And constitutional law. Constitutional law is a broader term and it includes all the provisions of the Constitution, of course. Even the statutory regulations, conventions, judicial interpretations. So we talk about legal norms as well as non-legal norms. And basically this constitutional law development, the credit goes to the judiciary. And we can take the example of that you have to construct some building. What you do? First of all, you need a land, which is main foundation. So we have the Constitution, which is the main foundation. Then you need architecture, designing, drawings, all these that we can take as constitutional law. The rules, the conventions, the interpretations, the developments, and finally, for constructing the building, apart from the material, we need certain permissions also. We have to abide by certain rules, regulations. Now, the moment we impose certain limitations or we talk about certain guidelines, we will refer to constitutionalism. But before that, because here we are not merely talking about constitutionalism, it's transformative constitutionalism. So we need to understand that constitution gives us, in fact, two pictures. We very commonly say every coin has two sides, every picture has two faces. So here one is when we talk about originality of the constitution. And second is the constitution is a living document. Originality, because originally whenever any country just has this constitution, some original pillars have to be constructed on which the constitution remains based and remains alive throughout the period. And why we talk about living a constitution? Because constitution must cater to the needs of the people, needs of the society. With the passage of time, interpretations change, needs change, and we have to modify it. And because every constitution has provision for amendment, it may be liberal provision, it may be rigid provision, it may be blend of both, as we have in India. And so we have to maintain both. But before I talk about in this context, keeping in view, because there is a chain, we have to maintain the originality. And then we have to make it a living document. And that document is a living document, which again I'll emphasize, which is as per the needs of the people, which devotes towards the welfare of the people. And again I'll be talking about that, how we presume certain basic assumptions before we talk about this transformative constitutionalism. Now, for constitutionalism and transformation, I would just refer to quote a beautiful shloka. Swasti praja bhaye paripalayantam nyayen margen mahi mahisha go brahmanebhya shubhamastu nityam loka samasta sukhino bhavantu. Which means, may the well-being of all people be protected by the powerful, and mighty leaders be with law and justice. May the success be with all divinity and scholars. May all the world become. And I think if this is kept in mind while thinking of even touching the constitution to modify it, to amend it, then we can talk about constitutionalism as well as transformative constitutionalism. Now, constitutionalism is the kind of guidelines, the limitations on the power to be exercised by all the three organs of the state. And we can, because we can clearly say that this is nothing but a check and balance. And the governmental powers can be checked, can be limited through different means. Like we need stability, maintaining the dynamism of the constitution. We need division of powers, but not to put it in a straight jacket formula. We need transparency, openness, disclosure, accountability. Now, all these are the limitations on the constitution, and which we take as constitutionalism. I can quote Dieter Grimm. He wrote in his book Constitutionalism, Past, Present and Future. He referred to the constitution where there are two meanings, two aspects which are dead. One is relating to when we say political conditions. Second is relating to political rule. And while referring to both these, then we have to talk about constitutionalism. So we will just formulate a base for understanding the presence, emergence, growth of constitutionalism. We may talk about need for political rule. I think immediately you can remind yourselves of social contract theory by Hobbes, Locke, and Rousseau. Here we can just think of, we were in a free state, but we never wanted war versus war. Every individual entering into war with other individuals, or entering into war with the social structure, or all kinds of morals, ethics, norms, whatever we may name. So we decided that we must submit ourselves to some kind of rule, some kind of power, so that our person as well as property is protected. I don't agree with Hobbes when he talks about absolute submission. Locke was little liberal, but Rousseau clearly talked about that if our person, our property is not safeguarded by the ruler, then we can change the ruler. And in fact, here you can take note of, when we refer to our preamble to the Constitution, we talk about the form of government. We talk about democracy. We talk about republicanism. So this is the need of the time, because constitutionalism wants to control this functioning also. Democracy, when we say what is democracy, we say democracy is the government by the people, for the people, and of the people. So we have this democracy, and this democracy again, because when we talk about political rule, then very important question of sovereignty is also there. And we may talk about external sovereignty. We may talk about internal sovereignty. Now, external sovereignty, we understand that we are not under anybody's dominance. We are independent. Gone are the days when British rule was there. And when we refer to internal sovereignty, immediately we are reminded of that we have the Constitution as a sovereign, and which devolves this power to we the people of India. And the preamble just starts with we the people of India. Having solemnly resolved, after using the appropriate wisdom, we had this Constitution, where we will be talking about the constitutionalism. And at the same time, I can just refer to one decision of S.S. Bola versus B.D. Sardana of 1997, where Supreme Court laid down certain principles like fraud on the power, fraud on the Constitution. Now, this was in a reference to lawmaking. Fraud on the power is legislature has the power to frame laws, and legislature does not use this power. This is fraud on the power. And fraud on the Constitution is when any legislation is made which is not in consonance with the Constitution. I think I need not to remind you that you can just refer to Article 13. We say, no law to be passed which violates the fundamental rights. And we have so many examples where the Supreme Court condemned something, saying that this is a flagrant violation of the Constitution. I hope you can again refresh your minds with the DC Vadhva's case, where the governor misused the ordinance making power, and this was taken as flagrant violation of the Constitution. So this is a fraud on the Constitution. So you can just link when we talk about this critical rule, that the Constitution is there, where this ordinance making power, pardoning power, executive powers, all the powers are vested in the executive. And limitations are imposed through judicial interpretations. Interpretations are there which we take as constitutional law. And once these become a guidelines, these become essential component, essential features of constitutionalism. We talk about ultimate shift from a police state to welfare state. And hint we get from preamble only. Preamble. When we talk about socialism, when we talk about secularism, when we talk about justice, social, economic, and political, when we talk about liberty, now all these talk about that we are in the present times ushering in a welfare state. Linking this with that now concept of justice has become predominant. Now here, just taking, I'll go into details a little later, but just for your consumption and understanding, I can simply tell you that it was only a stage immediately after the inception of the constitution, like we can talk about A.K. Gopalan, where we confined to law to be interpreted only as enacted law, not where we can find a place for fairness, justness, and reasonableness. But this is not the case now. Now we have so many examples that the state has converted into welfare state. And once we talk about welfare state, then we find a shift from merely vesting of power and converting it into that now it's not merely power, that we have to talk about duty. Again, I need not to remind you, 42nd Amendment Act 1976 added Part 4A of the Constitution, that is fundamental duties. Initially 10 duties are there, 11th duty was added by 86th Amendment Act 2002. And at the same time, when we talk about accountability and responsibility, now this is through judicial interpretation. I will be referring to this. If you remember, if you turn back the pages of history, we find, because much we have adopted from United Kingdom also, there was a saying, king can do no wrong. But this changed with the passage of Crown Proceedings Act 1947. And we have in the background, when we talk about different important principles, like we can refer to French Revolution also, where there were trinity of principles: liberty, equality, and fraternity. Just take note of it. We find a reference in the preamble. And I can talk about the constitutionalism as explained by the constitutional scholar David Feldman. And he said, I quote, constitutionalism is descriptive of a complicated concept deeply embedded in historical experience, which subjects the officials who exercise governmental powers to the limitations of a higher law. Constitutionalism proclaims the desirability of the rule of law as opposed to rule by the arbitrary judgment or rule by the public officials without following these. And at the we can say that the touchstone of constitutionalism is the concept of limited government under a higher law. And even Gerhard Casper, he talked about this constitutionalism, that constitutionalism has both, again, the same descriptive and perspective connotations. Used descriptively, it refers to the historical struggle for constitutional recognition of the people's right to consent and certain other rights, freedoms, and privileges. Used prescriptively, its meaning incorporates those features of government seen as the essential elements of the Constitution. And I hope you can understand that this is absolutely present under the Indian Constitution. If I just refer to fundamental duties, then one of the fundamental duties clearly talk about cherishing and protecting the what we gained out of freedom struggle. And further, when we talk about the limiting the government, I'll be referring to how through judicial interpretations, whether it's law enforcement or it's law making, how and what kind of law is to be made, all these provide for the limitations on the government's power. I would just like to quote Jeremy Waldron when he said, constitutions are not just about restraining, this is very important, restraining and limiting power, they are about the empowerment of ordinary people in a democracy and allowing them to control the sources of law and harness the apparatus of government to their aspirations. Now, this is nothing but when we talk about democracy, this is what is a democracy. And this is when we talk about even when we refer to socialism and democratic socialism, when we talk about informal equality and not formal equality, no individual equality, equality among masses. And immediately we can refer to, like in case of India, directive principles of state policy, which are the guidelines for the government and for becoming a welfare state. Specific reference can be made to Articles 39B and C, where we talk about equitable distribution of material resources and all income. Now, here we don't talk about that all equals have to be treated equally. Here we talk about the equality where the standard of living can be raised, where we have equality from cradle to the grave. Now, how can we may talk about the fundamental rights where we talk about equality, maybe when we have to seek admissions in the educational institutions, or when we talk about equality of opportunity in matters of appointment and employment. But real equality is when we get 2 square meals a day, when we have shelter at our head, when we have clean drinking water, when we don't have to fight in a court of law for water or food. That is the real equality. In Navtej Singh Johhar's case, beautifully Supreme Court remarked, I quote, this is regarding transformative constitutionalism. I quote, the concept of transformative constitutionalism has at its kernel a pledge, promise, and thirst to transform the Indian society so as to embrace therein in a letter and spirit the ideas of justice, liberty, and fraternity as set out in the preamble to our Constitution. I unquote. Supreme Court further stated, now this is how we have to link the question of having living document and this transformative constitutionalism. I again quote, it is the ability of the Constitution to transform, which gives it the character of a living and organic document. I unquote. I think this much is aptly clear to all of us that we have a constitution which talks about the principal organs, and we have 3 organs of the state: legislature, executive, and judiciary. Legislature to frame laws, executive to implement laws, and judiciary for judicial review. This concept originally was given by Montesquieu and then further defined by a number of writers, like we can refer to Wade and Phillips when he talked about three meanings to this separation of powers. First meaning, that no person should form part of more than one organ of the state. And second, no organ of the state should perform the functions belonging to other organs of the state. Third, no organ of the state should interfere in the functioning of any other organ of the state. Now, if we evaluate this in the present context, we find much as irrelevant. Irrelevant in the sense, we have the clear example. If we just talk about the constitution of parliament, the composition of parliament. Composition, what is the composition? Lok Sabha, Rajya Sabha and President. President is part of executive. Even the members of parliament, they are ministers who are part of executive. So we cannot literally apply this. And when we talk about other two meanings, again, we cannot fix in the watertight compartment. If we turn the pages of the sacred document, the Constitution, we find only Article 50, which talks about the separation of executive from judicial. Or if we want to know about the powers to be exercised, then we find like we can refer to Article 53, where says executive power vests in the president. We have the composition of the legislatures, or we do talk about the procedure for that. Indirectly, then we have to find out this power of judicial review, and we refer to Article 13, as I have already mentioned. We are very fortunate that we have the provision where we find this power of judicial review. Like in the American Constitution, for developing their constitutionalism, ultimately I'll be talking about even independence of judiciary. There, this was usurped in Marbury versus Madison in 1803. And if we look into even the provisions of the Constitution, you will find express provisions under the Constitution where we find ordinance making power which can be exercised by the President under Article 123 and Governor under Article 213. Similarly, pardoning power can be exercised by the President under Article 72 and by the Governor under Article 161. Now, question is whether ordinance making power is executive power vested in the President or the Governor, as the case may be. This is not executive power. This is legislative power expressly vested in the. Similarly, pardoning power is a judicial power, not executive power, again expressly vested in the executive. Now, here we talk about this is the Constitution, and constitutional law provides for this. And there are objectives behind it for vesting whether ordinance making power or a pardoning power in the executive. Then once submitted, once vested, we need some kind of limitations. And limitations are there when we talk about the duration for which the ordinance making power will remain effective, and then the limitation that control of legislature over the ordinance making power. Now, ordinance will become law only when it is approved by the legislature. Now, this is constitutionalism. And further, this development of constitutionalism, apart from constitutional law, we find in judicial interpretations. Judicial interpretations, limitations like I told you about DC Wadhwa, where this was misused, that you cannot go beyond that. If repromulgation is there, then again complete procedure has to be followed. Similarly, when we talk about pardoning power, again clear distinction is about the domain of exercise of this power by the president or the governor, as the case may be. And when we refer to constitutionalism, now this is constitutional law, we refer to constitutionalism, then I can talk about the journey. Number of issues when we talk about Kuldeep Singh's case of 1982, Bilnaranga case. The question was that there are no guidelines for the president to exercise this pardoning power, but Supreme Court did not find that appropriate stage to lay down the guidelines. We have the Kehar Singh's case of 1989. Then following further, we follow when we talk about Swaran Singh versus State of UP of 1998 or Satpal versus State of Haryana of 2001. These two cases clearly show the misuse of a pardoning power. So Supreme Court started giving direction. Right? Just it may be beyond your imagination that in Satpal versus State of Haryana, when the remission was granted, the person was not even in the jail. He got the release order then, and he went to just to surrender and then received the release order, the remission order. Now, all these situations show the misuse of power. Then came Sudhakar's case of 2006, and finally I can refer to Narayan Dutt versus State of Punjab of 2011, where the Supreme Court just combining different guidelines issued in different cases, all the cases I have mentioned, now clearly talked about that there is a limit on the exercise of this pardoning power, that it must be on the aid and advice of the Council of Ministers. How can we forget Article 74? Whether or 163, President or the Governor, they are bound by the advice of the Council of Ministers. And then it is very, very important that the President or the Governor must have applied their mind, application of mind. When there is application of mind, only then we can say the discretionary power is exercised in a valid manner. Now, what is the meaning of application of mind? That means that relevant considerations have to be considered and extraneous or irrelevant considerations have to be ignored. And so ultimately there are endless examples which I can give you, but I'm not going into the details about the separation of powers because lecture is not on separation of powers. But I would just like to refer to certain situations because we have to assign the functions to 3 different organs. This is a necessity. But we know there may be overlapping. Legislature frames laws. At the same time, by way of delegated legislation, executive also makes rules, regulations, bylaws, notifications. Similarly, nowadays we do talk about judicial legislation. And we have the best examples of Keshananda Bharati, where basic structure theory was laid down. D.K. Basu, where guidelines were laid down when the person is to be arrested. D.K. Basu of 1997. And we can also refer to Vishaka versus State of Rajasthan of 1997, where complete guidelines were there for protection of women from sex harassment at workplace. So, and that's example. So we can't avoid this overlapping because we want good governance, not merely open government. We want good government. So for that purpose, this overlapping may be there. So ultimately, we land into the conclusion that we can't have absolute separation of powers. We may have organic separation, But we must adopt a theory of checks and balances. Checks and balances. Again, what is checks and balances? Limitation on the power to be exercised by three organs of the state. No organ is superior to other organ. So this is constitutionalism. And limitation. How can you limit? Now, the three meanings were given by Wade and Phillips. I just talk about second and third. Now, here I would just change the statement and say no organ of the state should perform or interfere in the essential functions, not merely functions, essential functions belonging to other organs of the state. And for that purpose, we have to determine what are the essential functions. Many a time we have misconception when we talk about the essential functions of the legislature. We simply say lawmaking. No, because this can be further delegated to the executive also. Even as I told you, even judiciary is doing this. Now here, essential function belonging to the legislature is to lay down the legislative policy, whether a law is to be framed or not. Now, this is to be decided by the legislature only. No court can direct. In the absence of delegation of power by the parent act, the delegated legislation cannot be done by the executive. And you just read any act where which is framed after this judicial legislation, or when you read any judgment where we say the Supreme Court exercised this legislative power in a way, like we can take the example of simply Vishaka versus State of Rajasthan. The end part of the judgment clearly says this shall remain operative till the law is passed by the. So this judicial legislation comes into existence when there is a vacuum. And there's a good linking with the reason, that is, the state has to be a welfare state. If one organ of the state is sleeping in deep slumber, the other should not. And I can quote Justice Chandrachud's view on this separation of powers. I quote, "The political purpose of the doctrine of separation of power is not widely recognized. No provision can be properly implemented without a check and balance system. This is the principle of restraining, which has in its precept innate in the prudence of self-preservation that discretion is better than its valor." And we are very clear, old case of Ramjavaya 1950, where we in the beginning only talked that we don't recognize rigid separation of powers. Same was there in the case which is popularly known as the Bible of delegated legislation, that is Re-Delhi Laws case of 1951, that we don't recognize the rigid separation of powers. But I can give you the example that we recognize where nobody can interfere in the essential functions belonging to the other. We have beautiful decisions like State of Himachal Pradesh versus Umed Ram of 1986. Now, where the Himachal Pradesh High Court had directed the state legislature to construct roads in the interiors, even though the state government expressed its inability that they have to have budget for the purpose, and budgetary sanction will be given by the state legislature. Still, this direction was given. Now, when the matter reached up to the Supreme Court talked about that this is a policy decision which is to be taken by the government, where the state can, the court can only make suggestions, only advise, but cannot issue directions which are required to be enforced. Similarly, in another case of State of Himachal Pradesh versus a parent of a student of medical college in 1986, where again because of ragging, severe ragging issues in the medical college in the Himachal Pradesh, directions were issued by the Himachal Pradesh High Court to the state legislature to frame a law. again, when matter was before the Supreme Court again talked about that this, whether a law is to be framed or not to be framed, this is essential. This policy decision is an essential function belonging to the legislature. And in both the cases, Supreme Court evolved a new concept, which again becomes a part and parcel of Indian constitutionalism, that is judicial self-restraint. The judiciary must exercise self-restraint. Every organ has to function within its domain, and no organ can cross these limits. Then once we talk about the concept of power, concept of justice, concept of fairness, immediately we are reminded of how integral rule of law is a part, integrally this is a part of the constitutionalism. And for understanding this, before I talk about what is rule of law, I would just like to refer to that how Fuller, he formulated a concept of inner morality. Now, this rule of law is also inner morality of the Constitution. And for inner morality, he talked about 8 principles which must be there: generality, publicity, prospectivity, intelligibility, consistency, practicability, stability, and congruence. Now, all these must be present. And if we look at even Kautilya's Artha Shastra, we find the duties of the king in maintaining law and order in the society, because king is the guardian, so king has to act under the law. And again, I hope you are very clear about one saying, that the ruler or the king has to be under God and law. And in 1885, A.V. Dicey, he gave this concept of, clearly this concept of rule of law. According to Dicey, this rule of law means the absolute supremacy or predominance of regular law as opposed to the influence of arbitrary power, and excludes the existence of arbitrariness or prerogative or even wide discretionary power on the part of the government. And we talk about 3 meanings of this rule of law. First is absence of wide discretionary authority in the hands of government officials, and justice must be done according to the known principles of law. Second is just the same what we have Article 14, right to equality, that equality before law and equal subjection of all to the ordinary law of the land administered by the ordinary courts of the land. Third meaning, we are not concerned, because he talks about fundamental rights are not the result of the Constitution. We have a written Constitution where we are very fortunate that we are guaranteed fundamental rights. Now, if we just look at what Dicey said, because Dicey has been criticized a lot. It was a fashion to criticize Dicey, and Jennings did the most. Dicey may be right during these times, but in the present times, when he talks about, we fully agree with him when he talks about this anti-arbitrariness. But when he talks about in the concept of equality, that all are equal. Now, during his time, even in the present times, we do talk about privileges, immunities. Now we have Article 105, privileges of Parliament, 194, privileges of state legislature, 361, privileges of president and governor. So we have, even today, we had at that time also. And concept of equality, concept of rule of law has undergone a great change. We are very fortunate that we could talk of rule of law as a basic structure in Keshavananda Bharati's case. We could talk of rule of law when immunity was granted to the election of the Prime Minister, the case of Indira Nehru Gandhi versus Raj Narayan of 1975. Innumerable cases are there, but we don't have to live in old fashion. Now we have Rule of Law Index World Justice Project report. India ranked 69. And this report talks about, initially talked about 9 factors, but at present there are 8 factors to determine whether there is a condition of rule of law or not. The first factor is constraint on government powers. Now, constraint can be through, now one thing is very clear in India constitutionalism, constraint through the judicial control or the control of the civil society, media control, and ultimately we are a democracy, people control. Second factor is absence of corruption. No, it may be any sphere of life. If there is corruption, there cannot be justice, there cannot be fairness, and who will be the sufferer? The commoners. Then we talk about open government. All of us know open government requires transparency, information, participation by the people. No, this is what is required. Fourth is fundamental rights. Fifth is order and security. Sixth is regulatory enforcement. Seventh, civil justice. Eighth, criminal justice. And we can find even examples in the functioning of our system, how through judicial interpretation, we make efforts to enforce in a way all these factors. If I can take a few examples, like I may talk about the open government or constraint. I can refer to a decision of 2016, Youth Bar Association versus Union of India, where the Supreme Court directed for uploading of FIR by the police on the website. Now, how it talks about transparency, it talks about restraint on government power, on police power. When we talk about fundamental rights, I'll be talking in detail a little later, but just reference I can make, like new rights which have emerged. Subramaniam Swamy versus Union of India 2016, right to reputation. Case Putta Swamy, right to privacy. Even we talk about Anuradha Bhasin's case 2019, right to internet. Now, all these rights have become very, very important. When we talk about criminal justice also, much reforms have, many reforms have been there. Like, you can refer to Verma Committee report after the 2030 amendment, where the background may be, in fact, very scary. The Nirbhaya's case, and so many offences have been added. And even through judicial interpretation, I can just refer to one decision of 2016, like Mutinam Lingam versus State. When we talk about multiple life sentences, because now the trend is towards multiple life sentences, then they will go concurrently. And if one is remitted, it will have no effect on others. Number of, I'm not going into details of this. I can just give examples like of civil justice. When we talk about, I can refer to Anita Kushwaha versus Pushpa Sadan of 2016. Now the situation is totally changed after the abolition of Article 370. Earlier, there was no transfer of cases from to or from High Court of J&K, but this is the first case where the Supreme Court directed for such transfer. And when we talk about regulatory measures, I think there are flood of decisions by the Supreme Court. I can refer to a few, like Voluntary Health Association versus State of Punjab, where the Supreme Court issued guidelines for the implementation of PCPNDT Act 1994. Or I can refer to State of Tamil Nadu versus K. Balu, where the Supreme Court directed for closure of liquor shops within which are there in a particular limit at the national highways. Similarly, Arjun Gopal's case, where the banning of fireworks in Delhi, this is a case of 2018, So innumerable examples are there. In fact, I can just quote some observations by the eminent judges of the Supreme Court. Like I can quote Justice Deepak Gupta in Krishna Prasad Verma versus State of Bihar of 2019. Notably said, in a country which follows the rule of law, independence of judiciary is sacrosanct. There can be no rule of law, there can be no democracy unless there's a strong, fearless, and independent judiciary. The independence and fearlessness is not only expected at the level of the superior courts, but also from the district judiciary. This is very important. It's not that rule of law is in the lockers of the Supreme Court or the High Court. This has to be followed. In fact, everywhere, whenever we talk about administrative action, judicial action, quasi-judicial action, even we talk about legislative action, because no law can be passed which is not fair, just, and reasonable. Similarly, I can quote Justice Dr. D.Y. Chandrachud in Food Corporation of India versus Jagdish Balaram Bahira of 2017. I quote, as the nation evolves, the role of the court must be as an institution which abides by constitutional principle, enforces the rule of law, and reaffirms the belief that claims based upon fraud, expediency, and subterfuge will not be recognized. Once these parameters are established with a clear judicial formulation, individual cases should pose no problem. I can also quote Justice Deepak Mishra in the case of S. Krishna Shraddha versus State of Andhra Pradesh of 2017. I quote, a right is conferred on a person by rule of law. And if he seeks the remedy through the process meant for establishing rule of law and it is denied to him, it would never subserve the cause of real justice. Now you can find that how there is a relation between justice, rule of law, which is a concept of this constitutionalism. I would also like to quote Rohington Falinariman in the case of Kantaru Rajivaru. This is Sabrimala Temple Review case in 2020. Beautiful observation. The freedom to criticize the judgments of the Supreme Court is not being interfered with. Bona fide criticism of a judgment, albeit of the highest court of the land, is certainly permissible, but thwarting or encouraging a person to thwart the directions or orders of the highest court cannot be countenanced in our constitutional scheme of things. After all, in India's tryst with destiny, we have chosen to be wedded to the rule of law as laid down by the Constitution of India. Beautiful. I continue. Let every person remember that the holy book is the Constitution of India. And it is with this book in hand that the citizens of India march together as a nation so that they may move forward to all spheres of human endeavor to achieve the great goals set out by this Magna Carta or Great Charter of India. I hope this one para is sufficient to understand what is a constitutionalism. Because here we talk about independence of judiciary, a rule of law, respect for the grand norm, the Constitution, and in the link now we follow with another component where we talk about constitutionalism. This is independence of judiciary. Must understand there can be transformative constitutionalism only and only when the judiciary is independent, when the judiciary works without favor or fervor or fear. I can quote Chief Justice N.V. Ramanna. He is addressed at the P.D. Desai Memorial Lecture. He said, "No, Now, this is when we talk about independence of judiciary, when we talk about our democratic rights, when we talk about welfare state, when we talk about justice. I quote, it has always been well recognized that the mere right to change, you'll be reminded of social contract theory once again, right to change the ruler once every few years by itself need not be a guarantee against tyranny. And again, I quote Justice Ramanna when he says, for the judiciary to apply checks on governmental power and action, it has to have complete freedom. The judiciary cannot be controlled directly or indirectly by the legislature or the executive, or else the floor would become illusory. And I think we need to remind ourselves. We talked about judicial self-restraint, separation of powers, and there can be judicial self-restraint, or there can be this checks and balances, this kind of exercise by the judiciary over legislature and the executive, about which we have so many examples, only when the judiciary is independent. Now, we have passed through different stages and struggled to make the judiciary independent. In fact, we can start from, we have so many judges transfer cases, that how we evolved ultimately in 1999 in a re-presidential reference case, that for making appointments, there will be a appointments of judges, there will be a collegium system. And we were following the collegium system when the 99th Amendment Act was passed in 2014, and where a National Judicial Appointment Commission was there for making such appointments. And the way we started, there was not a complete balance in the beginning also. Tilt was towards the executive. So again, the tilt came in favor of the executive. But this was struck down by the Supreme Court in Supreme Court Advocates on Record Association versus Union of India in 2015. And the ground for striking down this NJAC 99th Amendment was that this violates independence of judiciary. And here I must tell you that I talked about originality, I talked about a living document, and only when we have a living document, we can have transformative constitutionalism. We can have transformation. So the first thing, in fact, again, we have a note of appreciation for the Supreme Court, for the highest judiciary. First thing we need for that purpose is protecting our constitution. Now, if the base is not strong, no structure can stand and survive on that strong base. So putting limit on the power of the parliament, amend the constitution. In Keshavananda Bharati in 1973, Supreme Court evolved the concept of basic structure, that there are certain important pillars of the constitution. If taken away, the whole system will fail. So in order to protect the system, and here I would just like to say, why originality? Because here, thank God, the 13 judges bench, 7 majority in favor of protecting, favor of basic structure. The remaining 6, the minority, they even went to the extent of saying that the constitution can be changed with one stroke. So what we need? Now, the question which is open to all of us, but keep on reviewing, revisiting from time to time, that do we want to take away the certain basic structures of the constitution? Do we want that there should not be secularism? Do we want all the time decisions by the Supreme Court intervening on one issue or the other, like mob lynching, or when we talk about nowadays the controversy which is going on about hijab? So all these issues, if we want to save, then we need to empower the judiciary also. But of course, the judiciary cannot violate the concept of constitutionalism. And going further, in fact, because I said constitutional law includes the judicial interpretation. Through judicial interpretations, we make our document a living document. Wherever we need, we bring changes. And wherever we need, we impose limitations. Like best example after this basic structure, I can talk about that how Maneka Gandhi, we adopted American procedural due process, which is, and in Mithu versus State of Punjab in 1983, when Section 303 of Indian Penal Code was declared unconstitutional, we adopted substantive due process. Now, by adopting the American due process clauses, we impose limitations on the legislative function also, that every law has to be fair, just, and reasonable. And every law has to prescribe the procedure which is fair, just, and reasonable. And while distinguishing, because ultimately when the question of exercise of power by the executive or the government is there, then also we talk about discretionary power and not arbitrary power. And for that purpose, again, innovations by the Supreme Court. We have a right to equality. Initially, we confined this right to equality to simply no discrimination principle, concept of reasonable classification. Now, this is after E.P. Royappa versus State of Tamil Nadu in 1974. We talked about that in case any power is exercised arbitrarily, then Article 14 is the touchstone. And going further, the Supreme Court, in fact, borrowed a principle from United Kingdom, that is Wednesbury principle, which was evolved in United Kingdom in the case of Associated Provincial Picture House Limited versus Wednesbury Corporation in 1947, which literally meant to act fairly. And the English courts talked about that if any action is to be taken, any decision is to be taken, then there must be plausible justification for taking that particular decision. The same we adopted in Delhi Science Forum versus Union of India in 1996. Again, that whenever decision is to be taken, we have to focus on the relevant considerations. Similarly, we talked about doctrine of proportionality, which is again a limit on the exercise of power. That we put on the one hand, on the balance, on the one hand of the balance, the wrong which is done, and on the other hand, what action is taken. It must be proportionate to that. So this is common sense, in fact. Simple concept of justice. I cannot be harmed more than the wrong which I committed. This is absolutely clear. Now, out of this, because I must say, constitutionalism need a revisit if we simply talk about limits and do not prescribe the control. And the control mechanism was prescribed by the Supreme Court by innovating the concept of public accountability or personal liability, that those who misuse the power must face the consequences. Now, the endless examples are there. I may talk about Krishan Yadav's case of 1994 or M.K. Gupta of 1994. Krishan Yadav, where the selection committee was there of the excise inspectors in State of Haryana, and selections were made, lists are prepared, but then suddenly what happened? Now, I said that when I talking about the factors of rule of law in the Rule of Law World Justice Project report, we talked about one of the factors, that is absence of corruption. And here, because of that, new appointments were made, merit lists were changed, answer sheets were destroyed, matter was referred by the Supreme Court. CBI investigated and found all the charges of fraud, nepotism, favoritism as true. Here, the Supreme Court imposed personal liability. Compensation to the victims to be recovered from the pockets of the chairman and members of the selection committee. Many examples are there, like I said, M.K. Gupta, where a person applied for the house, he's completed all the formalities, still the person needed something from under the table or something else. he was not able to, or he did not intend to be part of this corruption. So yeah, again, the matter reached up to the Supreme Court, question of this fraud, favoritism, and so on and so on. And ultimately, again, here the state was directed to pay compensation to the victim, and the compensation to be recovered from the pockets of the guilty officials. Till date, we have innumerable examples, because if I have to talk about it, I need full one lecture to talk on this. So I just proceed further. Then, as I said, living document has to be in consonance with the changing living conditions of the society. And we can just refer to how we had a section, the 66A of IT Act 2000. I hope you can remember. Any annoying remarks on the social media? I don't know. For me, this is unfortunate that we had Shreya Shingal's case. For many, it may be fortunate that there was Shreya Shingal's case, and anybody may write anything on the social media without stepping into other person's shoes. What kinds of difficulties, what kinds of problems, in which situation the other person may be. We are free to comment, interfere in anybody's, intrude in anybody's life, irrespective of the fact that 2017 Supreme Court clearly settled the principle that right to privacy is a fundamental right. But the living document, now these are the limitations. Now, apart from that, there were days how we used to look down upon the vulnerable sections of the society. We may talk about women, even though I don't agree that we are a vulnerable section of the society. If we have the some issues relating to our physique, those are our privileges, womanhood, motherhood. But that gives a chance to misuse it to the society, to the bad version of society. And if the guidelines are there by the Supreme Court in number of cases, if the legislations are there, now these are again the limit on our fundamental rights, because nothing can be absolute. Similarly, I can talk about that how we needed to change. I hope all of you can remember the status of hijras, whom we call nowadays transgenders. How the terms kept on changing, whether we talk about disabled, person with disability, handicapped, and now it's a divyang. So it's not merely language or a body language, it's the question of recognition of their identity. It's very, very important. How can we forget National Legal Services Authority versus Union of India of 2014, where the rights of transgenders was recognized. Even they were taken as socially and educationally weaker. Reservations can be made for them. They were recognized as third gender. Now we are bound to include, whenever we prepare in any organization, any kind of form, we say male, female, third gender. And similarly, going beyond that, even the Supreme Court recognized in the Singh case LGBTQ right after a long struggle, passing through. We know how much discussion and what kind of literature was created in Suresh Kumar Kaushal versus Naz Foundation, Delhi High Court's decision. But ultimately, we landed to this. And similarly, the struggle by the Muslim women, I hope you can remember Shaira Bano, Shah Bano, and then Shaira Bano. Shaira Bano, just imagine, I think it will be a nightmare. How these Muslim women used to sleep before that? They don't know. The next morning, they will get just 3 words, talaq, talaq, and talaq, and they are no more in matrimonial relationship. Now, it was for the first time the Supreme Court included this personal law in the term law under Article 13, and this is declared as unconstitutional, being violative of Article 14 as well as Article 21. And 21, when we refer to, see, today you mention any kind of right. Now, this is Just keep it in your mind. This is one of the limitations imposed by constitutionalism on the governmental power, that your fundamental rights cannot be violated. No law to be passed which violates fundamental rights. No governmental action can be taken which violates fundamental rights. And duty of the judiciary to protect these fundamental rights. So the Supreme Court, now this job was performed by the Supreme Court. This right to life was declared as including right to live with human dignity. Whether we can refer to PUDR versus Union of India of 1982, they are giving minimum wages to the Asiad workers. If minimum wages are not paid, this affects their dignity. When we talk about Francis Coley Moline versus Delhi administration of 1981, where the Supreme Court talked about the dignity of the prisoners, that they have a time of theirs, time to relax, time to leisure, time to meet their family members, their friends. And most of the cases where we talk about offenses against women, like rape committed against women, Supreme Court in number of cases talked about this human dignity. Like whether I may talk about Chandrama Das case after 2000, where a Bangladeshi woman was raped in Railway Sarai. And innumerable cases are there. Now, out of this dignity, we understand what is dignity. I'm reminded of Rabindranath Tagore, who says, when my head is high, that is dignity. When I don't have any fear of any social media, that is dignity. This I can say on any platform. When I am protected from intrusions by the social media, then I have a dignity. Dignity which includes your identity, your autonomy. Autonomy, what is autonomy? Many a time we say, our institution is autonomous, but I'll say each one of us is autonomous. We have control over ourselves. Now, autonomy does not mean liberty, does not mean dignity, does not mean that I can violate other person's dignity, other person's autonomy. Even the autonomy includes my right to get married, to produce children, anything. I can refer to Suchitra Shrivastava versus Chandigarh administration, where this was talked about by the Supreme Court. I can refer to Lata Singh's case of 2006, Arumagam Sirvai of 2011, where the Supreme Court condemned the honor killing and Kha Panchayats, referring to that you have a right to marry a person of their choice. Now, all these issues, in fact, these are the limits. This is a great component of constitutionalism. And constitutionalism further landed into something through judicial interpretations, what was talked about by the Supreme Court in number of cases, that is about constitutional morality. What is morality? Morality is difference between right and wrong. When we talk about constitutional values, when we talk about difference between what is constitutional, what is unconstitutional, this is nothing but morality. When we talk about equality principle, this is morality. When we talk about freedoms, when we talk about there should be no chilling effect, when in the present times even the Supreme Court went to the extent of talking about this doctrine of chilling effect, which was adopted by the Supreme Court from the American Supreme Court in Anuradha Bhasin's case. This has been continued. Even the Pegasus case, Supreme Court referred to this. Now, constitutional morality is not, in fact, what the claim is made by the Supreme Court is a new concept. But I can just talk about even Dr. Ambedkar talked about this constitutional morality. I just talked about. He said constitutionality morality was not to be used by courts to invalidate legislation or government action. Simply, he used the gross idea as a persuasive or rhetorical device to justify why seemingly mundane details about the administration of the government had been in Constitution of India. He said constitutional morality means an effective coordination between conflicting interests of different people and the administrative cooperation to solve those issues or conflicts amicably or in friendly way as far as possible. Number of cases, whether we talk about Sabrimala issue or Navdev Singh Johar or Joseph Shine, where adultery was declared as unconstitutional, Supreme Court did refer to constitutional morality, distinguishing between right and wrong. And in NCT of Delhi versus Union of India in 2018, Supreme Court observed that what is morality in constitutional terms? Morality is constitutional norms, and what is really worth appreciating, conscience of the Constitution. And I would say, well, this is soul of the Constitution. We need not to refer to any nomenclature. We know this is flowing throughout the Constitution, which is constitutional morality. And I would just like to quote Chanakya, and this is in fact constitutionalism. What Chanakya said: Saten dharyate prithvi, saten tapte ravi, saten vati ishya sarvam satte pratishchitam, which means the earth is supported by the power of truth. It is the power of truth that made the sun shine and the winds blow. Indeed, all things rest upon truth. This truth is constitutional, and which is very, very important to understand. And finally, I'll just conclude, as all of you know, that I am a poet by heart. So I'll just talk about a poem on constitution, which of course imbibes constitutionalism. कौन कहता है कुछ पन्ने हैं संविधान, कौन कहता है कुछ पन्ने हैं संविधान, मेरा रब, मेरा धर्म, मेरा अस्तित्व है संविधान। विधिवेता लेखकों ने कलम से जाप किया इसके मंत्रों का, मगर कठिन है अनुमान लगाना इसके तंत्रों का। इसके फैलाव का कोई सानी नहीं जहां में, साझा करना अच्छाई दूसरों की नहीं आता गुनाहों में। नागरिकता संभाल दरो दीवार का बनाता है मालिक, राज्य के तीनों अंगों की स्वाधीनता के समन्वय से कराता है वाकिफ। नागरिक होने का हक और व्यक्ति होने का एहसास दिलाता है, मौलिक अधिकारों के दायरे में प्रभुता और शक्ति बांधता है। समानता के तराजू में समान स्तर पे ही तोलता है, स्वतंत्रता के गागर को 19वीं धारा की गागर में खोलता है। अपराधी न रहे, बिछी है न्याय की बिसात, अन्याय ना हो किसी मासूम से सुरक्षित है उसकी भी औकात। जीने का अधिकार यज्ञाग्नि सा जल रहा है, जीने का अधिकार यज्ञाग्नि सा जल रहा है। सर्वोच्च न्यायालय की मेहरबानियां अधिकार अनेकों बहते हैं कल कल। अनुचित हिरासत व निरोध का करता है विरोध, नर नार बाल शोषण का है स्पष्ट अवरोध। अल्पसंख्यक अनुसूचित जातियों जनजातियों का विभाजन घातक सा लगता है मगर है एकता अखंडता का वरदान। हक का दर्द बहुत गहरा बताता है उपचार, हक का दर्द बहुत गहरा बताता है उपचार। ऑल रिट्स बंदी प्रत्यक्षीकरण परमादेश प्रतिषेध अधिकार प्रचारोत्प्रेषण का है व्यवहार। हक की मृत तृष्णा में कर्तव्य क्यों बुलाता है बंदे, हक की मृत तृष्णा में कर्तव्य क्यों बुलाता है बंदे। तेरे हकों की अदायगी में है मेरे अधिकार बंधे। दायित्व है सरकार का सामाजिक आर्थिक न्याय जीवंत करने को, दायित्व है सरकार का सामाजिक आर्थिक न्याय जीवंत करने को। निर्देशक सिद्धांत है मानवीय दुखों का अंत करने को। स्थिर है चाहे संविधान की प्रकृति, स्थिर है चाहे संविधान की प्रकृति, मगर जरिया है बदलने की इसकी प्रवृत्ति। इसके अंशों अनुसूचियों में बसा है भारत का भाग्य गहरा। संशोधन पे बुनियादी संरचना बेसिक स्ट्रक्चर, संविधान पे बुनियादी संरचना का लगा दिया है। एंड फाइनली आई कंक्लूड, ए रब तेरे बात गर आशिकी की तो इस देश से, रब तेरे बात गर आशिकी की तो इस देश से, बहुत गर्वित हूँ इस संवैधानिक परिवेश से, बहुत गर्वित हूँ इस संवैधानिक परिवेश से। थैंक यू। सर्वे भवन्तु सुखिनः।
Thank you so much, ma'am. It was Indeed, quite informative and elaborative session. Ma'am, there are a few questions in the chat box, but before that, I want to ask something from you. It's not basically a question. I just want to know your views on it. Uh, Ma'am, do you believe that the doctrine of transformative constitutionalism, though it is necessary to ensure that it does not become a dry piece of document, but nowadays it is used as a weapon to pass laws, thereby diluting the position of the other organs of the state, particularly the legislation. And I'm speaking this in the context of Sabrimala case, where the social practices were, the judiciary interfered with the social practices and by using this doctrine. Just want to know your views on this, ma'am.
Social practices. Now, before I answer your question, perhaps I kept on talking about constitutionalism. I did not talk about mentalism. That first of all, we need to change our mindset. We cannot continue with something which has become obsolete, which has no logic, nothing of the sort. But the problem is, if we don't want to be uplifted, if we don't want any growth or transformation in our lives, as I talk about identity, dignity, autonomy, I think these three carry the answer of your question. What was done by the Supreme Court by majority in first Sabrimala case, and the review is pending. Now, if we don't want, that is why we feel that there is interference by the Supreme Court in the social practices, interference by the legislature in the social practices. Beta, had the legislature or the judiciary not interfered, we would not have that Sati Act today. And I think the cries of Roop Kanwar would have still been hurting us till today. You could have heard the echo. See, I don't want to intervene in any such critical, controversial issue, but my personal opinion is that I have very broad attitude towards everything. We must change with the changing times. It's not that there was once upon a time there was a snake. We used a stick to kill the snake. Snake left, and it has become a ritual that every day on that, every year on that day, we have to hit the earth with the stick because we used to do it long ago. Now, technologically, we are so advanced, medically, we are so advanced. There must be some logic behind whatever is done, but we have to weigh it again on the litmus test of logic in the present times. I think you got the answer.
Yeah, yes, ma'am. Thank you so much. Ma'am, there's another question by Mr. Hartej.
Please.
Yes, slightly longish question I have, and some of it is my opinion also. When we talk about constitutionalism, ma'am, it's based on the fact that we have a constitution. Now, one of the critiques of the constitution itself is that it was a sort of a constitution that was imposed by the elites of that time on the entire country. It is a sort of a liberal constitution that has been imposed on an illiberal society. Now, you said that people, in the Sabrimala answer that you just gave, that growth and transformation is needed in the lives of people, right? Some people might not want this growth and transformation because inherently the society is illiberal. And flowing from that, this is the sort of the first point that I have. When you mentioned the case of Marbury versus Madison, wherein the power of judicial review was usurped. Now, some also argue that Marbury is a wrongly decided case law because Chief Justice Marshall was himself a party. But anyways, therein Chief Justice Marshall said that it is emphatically the province and the duty of the judicial department to say what the law is. Now, when we talk about transformative constitutionalism, Judiciary has gone into lawmaking as well. Now, what my understanding of transformative constitutionalism is that judiciary takes on more power than it was given initially or originally through the garb of transformative constitutionalism. And in fact, most exercises in this transformative constitutionalism are usurpation of powers, which was not originally intended by the framers of our constitution. Now, if you look at certain cases such as the Supreme Court deciding how many ponies should go up to Vaishno Devi, Delhi High Court was once deciding what will be the height of the speed breakers, this closure of liquor shops also on the highways. These are not constitutional questions, but if one is smart, and one is willing to use fancy words and fancy verbiages and through literative chicanery, any issue can be converted into a constitutional issue if it involves human life. Because law takes a hold of you before you are born and does not leave you after you are dead also. So my question is that, and the fact that the courts take over this sort of extra power that they had, then it is subsequently abused also. As a basis of this transformative constitutional, courts take more power than they have, and then it can lead to an abuse. Also, something that is not discussed is the recent Madras Bar Association case, wherein the courts struck down the Tribunal Amendment Act, I think it was, and they made a whole scheme and laws wherein they decided what will be the salary of the judges, what sort of accommodation will they be given. That is the judges of the tribunals or the members of the tribunals. And all this is justified in the name of the transformative constitutionalism. The fact that we have given the courts the responsibility to sort of run this country. Another example would be perhaps the marital rape case that is going on in the Delhi High Court, wherein there is an explicit exemption to marital rape. Now, that should come from the legislature if it wants to be removed. It is not the domain of the courts to go into such questions, because these are explicit exemptions that have been carved out by the legislature itself. And going from back again to Marbury, it is emphatically the domain of the judiciary to state what the law is, not to again make the law. So this is my question, that it leads to sort of more usurpation of power.
Mr. Kuchid, in fact, all your queries I have answered in my lecture, but still to satisfy you. See, I started with the division of powers, but not rigid division of powers. And at the same time, I just talked about that the way you are talking about this judicial legislation, right? I expressly refer to the principle of judicial self-restraint. Number of cases, innumerable cases. This is one situation. Second situation is you can find that many of the such high court decisions, like about the skin test, what happened to that, and some other high court decisions which are overruled by the Supreme Court. Now, it's after all, because I'm reminded of Justice Frankfurter of the Supreme Court of America. He said, human mind is not a blank piece of paper, it is full of biases. After all, judges are also human. It is not that errors cannot be committed. See, if there are changes or revisiting of different decisions which are taken by the Supreme Court few years back, again we are changing those. This is the reason, because with the changing times. And I also told, wherever judicial legislation is there, because jurisprudentially also we have different schools where we question whether judges are there merely to declare law, judges to make law. There's an opinion in favor of that they can. But if you can remember, I made one statement: judiciary can make laws only in a vacuum. See, I started with certain assumptions that we are now living in the times where the state has to be a welfare state. See, what to do? Should we confine all the functions in the watertight compartments? Legislature does not frame law. Even if the legislature frames the laws and the executive doesn't implement. We have the living example. 44th Amendment Act 1978 amended Article 22. Till date, it is not. And the court, it's not all the time we can impose allegations against the court. In A.K. Roy, court refused to direct for implementation. Most of the cases, such directions have been not acceptable to the courts, that they refuse to issue such directions. And Supreme Court itself said that Supreme Court can advise. And I think there's no harm, but number of stages we had been talking about that judicial activism is acceptable to us, judicial adventurism is not acceptable to us. And one thing I think you will also agree that if the judiciary cannot act freely, then what will happen? We can have chaotic laws, exploitative laws, right? And law which is enacted by the legislature, any law. Power of judicial review, what is power of judicial review? If we go to the meaning of judicial review, this is nothing but testing the constitutionality of the laws of the executive action. And this is what they are doing. And while performing that action, when guidelines are issued, those guidelines may not be party specific, may be in a general, so they become a kind of law. And don't we appreciate the basic structure theory given by the courts? Don't we appreciate? Otherwise, what would have happened? You can see the consequences. That is why I always make one statement. Whether we are individuals, whether we are part of the legislature, whether we are part of the executive, whether we are part of the judiciary, in fact, the only one thing is that we need not to be biased. That is why I talk about fairness. And we should not be, in fact, influenced by our prejudices, and undue interferences should not be there. A number of situations are there. There is no disagreement on that. That what is the function of the legislature need not to be performed by the judiciary. There is no second opinion about it. I can give you the example also of 1979. Now that was the time there was a lot of discussion going on. Should capital punishment be retained or abolished? Even this was proposed before the Supreme Court, if you can remember, that the Supreme Court should issue directions that for the abolition. And I can remind all of you that the observation, the statement of Justice Krishna here in Vishnu Dev Shah's case, that only Parliament can pronounce death on death sentence. Right? So, of course, while testing the constitutionality of any law, and then because as I told you that in the modern constitutionalism, we do talk about the concept of duty, responsibility, and accountability. And just recently, you must have read the intentions of the Supreme Court to make fundamental duties enforceable. And now if you say they are using this transformative constitutionalism for this purpose. See, when we have the issues of communal violence, one few fundamental duties when talk about respecting the national flag, respecting the national anthem. Ultimately, you have seen Shamnarayan Choksi. How many Shamnarayan Choksis are there? Even this could not be enforced. Only thing is, all the three organs have to make the best efforts, coordination among all the three organs. But of course, citizen-friendly, human beings-friendly approach should be there. And see, just today only there was a Delhi High Court decision quoted that CCTV cameras, when affixed in the classrooms, will violate the right to privacy of the students. So it can be done only with the consent of the parents, students, and teachers. So this is, in fact, we are, when with the advancement of technology, We have given invitation, open invitation to number of problems. And while tackling those problems, then there may be overreaching effect by the judiciary, because the legislature's function is time bound. Simply, I ask you, a person is drowning and there is no law under which I can save any person. If I save, I may be made liable. I'm just presuming. Should I simply tell, look, wait, let the parliament sit and frame the law and come, I'll come and save you? No. We should not have that kind of approach. And of course, the basic thing, the basic spirit of constitutionalism rests on fairness and concept of reasonableness. And for that purpose, you can take the example of seeing those factors of rule of law or Justice Project report. In fact, there was a petition before the Supreme Court in October 2020 that the Supreme Court must form a panel to find out why we are lagging behind in the rule of law index, why we are at 69th position. Now just imagine whose job it is if we just try to deliberate over it. Does it mean if this is to be done by the executive or the legislature, we could not make effective in the Lokpal system or Lokayukta system? We have so many laws, but unless and until these are made effective through judiciary, they remain paper promise only. I hope, Mr. Kochhar, I have satisfied you.
Yes, ma'am. Thank you.
Ma'am, there are a few more questions by our participants.
Madam,
May I? Yes,
can
sir.
I talk something? Good morning,
Yes,
madam.
sir. Sure, sir.
Good morning.
Just to enhance the discussion on the subject, what Mr. Hardeep Singh Kochhar has raised, I want to show one news item. I have been given presentation rights, and then I want to ask him, what should the Honorable Supreme Court do in such a situation? A law is passed by the Parliament. The law creates certain courts, and the executive does not appoint the judicial officers in the courts, and courts become dysfunctional. So what the Honorable Court should do in such a matter?
Of course, the duty has to be performed. See,
This is the news item. So what would be Mr. Kochhar's take on the subject?
after a gap of 28 years,
The high courts will take up the debt recovery cases for adjudication, albeit temporarily, on the request of the Supreme Court, which on Thursday
Yes.
found that crippling vacancies have rendered DRTs.
Sir, this is the reply to what kind of query Mr. Kochhar has. Because here should
Exactly,
we
that is
sleep
what I'm
over
saying.
it.
That is
Sleep
what
over
I'm
it.
saying. That is.
We cannot sleep
is-
over it.
Ma'am, I still don't agree with that. This is the job of the courts to make sure that judicial vacancies are filled up, because that is my personal view. You obviously have a right to disagree with it, because at the end
So,
of the
Kochhar,
day,
I appreciate your personal views, because unless and until there are healthy views, we cannot reach to the conclusions logically. So I appreciate,
yeah.
fully appreciate, because see,
Madam,
we are all lawyers, so we can talk from any side with great weight. So I always appreciate your view also. And I had a number of such students in my class also, because I can share with you, in Punjab University, we used to have evening classes, all bureaucrats criticizing judiciary like anything. And then they had to show their faces also. See, these are the cases what you did. so,
Madam,
we,
one
we
comment,
can't have
one
absolute
comment and one
malice.
question.
There will be tilt. Please.
One question, one comment first, and then the question. If we accept the view of Mr. Kochhar, then possibly no law passed by the legislature can ever be declared ultra vires of the Constitution. See, legislature has.
Sir, we have the examples that Supreme Court declaring unconstitutional, they are again passing, thinking that we can do, yes, they can do it. But again, that will be subject to test of constitutionality by the...
Exactly. But my question is this, madam.
Shraddha, there is
Yes,
one
sir.
question
Hello.
by Dr. Anjay Kumar also.
Yes, ma'am. So, ma'am, he has 5 questions. So, first question from him is, can governor
No,
grant
I think
pardon
you
on the
just,
death penalty?
we have already taken so much time
Yeah,
off,
we have
ma'am.
six. Yes,
So, can you unmute that person, Dr. Anjay Kumar? I think he was
Kaushik
ma'am's
sir.
student only.
Yes, yes. Kaushik sir, can you please do that?
Yes, I'm doing.
Yeah.
If it is possible, otherwise read out the question because we are short of time.
Anjay Kumar.
In fact, I would have loved to see his face because I don't remember all my students by names.
Good morning, ma'am.
Good morning, beta. Can you switch on your camera and I can see you? Because you are seeing me for the last 1.5 hours.
Ma'am, there is an internet in my building, so by camera, I think I can't communicate properly.
Okay.
So,
You are
ma'am,
most welcome with your question.
yeah, ma'am. So there are 1 or 2 questions that in last year there is one judgment from State of Haryana versus Rajkumar Urf Bittu. So in this case, a governor can impose or grant pardon on the death penalty also. So when we are teaching in the classes, so sometimes there is a question that earlier where it is written that governor can't impose or reach to the or grant pardon on the death penalties. So is it written or it is interpreted, ma'am?
It is in there only in the Constitution. You read the Constitution carefully. That when we talk about the distinction between the pardoning power of the president or the governor, then pardon cannot be granted by the governor. Of course, he can remit or something, conversion also. But see, distinction is made. Pardoning power is only in exceptional situations, because pardoning power clearly means absolving any person of whatever he has done, as if nothing has been done. So this is clearly under the Constitution. If you read the provisions 72 and 161. And we have innumerable examples where the governors either complete files are not produced before them, or they did not apply their mind, or their decisions, remissions are based on irrelevant considerations. So let this decision of the writ petition come, and let finally it reaches the Supreme Court. There may be new interpretation of the Constitution. And as Mr. Kocher talked about, the judiciary will lay down new constitutionalism.
Okay, ma'am. Then, ma'am, second point is today near about 5% of the people in the world are ruled or comes under the genuine democracy. So when we talk about the constitutionalism, so there are some points on which your take on is required. That sometimes it is also said that what is written, that is not the constitution. So we are controlled by the hidden code or operating code.
Dr. Anjay, I started with this, perhaps you missed. I started with this. The two sides of the Constitution. One is originality and second is living document. Originality is what is written. Living document is because we need to change the Constitution. And as I told you that we have the blend of the system that what is neither rigid nor absolutely flexible, that we can amend the Constitution. And that is why so many amendments, 105 amendments dictate, because we need a living document. Would you like to live with a stagnant document? Would you like to live where we were in when Constitution was framed, and A.K. Gopalan was decided, or when MP Sharma's case was there, where no question of right to privacy. Would you like to confine to that age?
No, ma'am, we want to change with the time.
Yes, yes. Constitution is written, but there is a provision to change it as per the needs. And because this power should not be misused, the Supreme Court laid down the basic structure theory, that the basic structure of the Constitution will remain untouched.
Okay, ma'am, thank you.
Thank you. Thank you so much, ma'am, for spending so much of time. I would now like to request Professor Dr. Komal Odich to formally propose the vote of thanks.
Today I don't want to miss an opportunity to ask her a question. Because this is the first time, I am getting this opportunity, so I don't want to miss it. So, ma'am, my very small question is that, Justice Bhagwati was there in ADM Jabalpur case also, and then he propounded public interest litigation in SP Gupta's case. So, do you think this rule of discretion, what we call discretion of the judges, is against rule of law?
No, I don't agree with that. In fact, this is not the platform where we can discuss the political background, why Justice Bhagwati delivered such judgment in ADM Jabalpur.
In other cases also we see.
Yes, there are mostly political background, but I take it, because this is my personality, I take everything in a positive manner. Positive manner is that one wrong does not justify another wrong. If some wrong decision is there and I'm asked to review it, I will always welcome it. And this is my philosophy behind it. Why should we have this ego that I took this decision? That way, no decision can be revisited. Now, Justice Chandrachud will say, my father took this decision, and by virtue of our society, morals and all that, I have to follow whatever my father said because he cannot be wrong. No, even I may be wrong. Today, what I say that may not be right in the circumstances tomorrow. So I must change. I don't mind it.
Thank you so much for sharing your opinion. And on behalf of all the participants and Faculty of Law, SRM University, my sincere and heartfelt thanks to you for taking out. In fact, we have really taken your time today, but you have always been wonderful in enlightening us on different aspects, legal aspects. In fact, earlier also you delivered a beautiful lecture, on Constitution Day. And today also, I think somewhere as the part of this development program, we realize how important it is, because when we are teaching to undergraduate students, somewhere we miss this. We straight away go to the articles and we forget that we have to start from constitution, constitutional law and constitutionalism, and this transformative constitutionalism has become a significant aspect there. And you started with, explained every aspect so well that how the original pillars are there. Just now you answered the queries also, but we have to change with time. And that is mainly the changing needs, the welfare of the people, and we have to modify it. We have to make it a living and organic document. And you explained how it has the presence, emergence, and growth of constitution through this transformative constitutionalism. Very aptly, you mentioned about the jurist opinion and how it is more important now to have a welfare state where justice become the dominant feature. Liberty, equality, fraternity, all these are important aspects when it comes to transformation. But the different, aspect, how the constitution itself has certain provisions, there is separation of power, rule of law, but you put more emphasis on judicial interpretation when it comes to transformative constitutionalism. And I totally agree with you, I think all the participants also, for that, we have to have the strong, independent, fearless judiciary. And ultimately, we have to abide by the sacred book, that is the Constitution. Thank you so much for a very marvelous, session. and bejeweled with your beautiful shlokas and poetry. And thank you so much for giving us so much time today.
Thank you, Ji.
Thank you so much, ma'am.
Thank you, beta. Thank you.